As my lady knows, Mr. Mably, Queen's Counsel, represents the Crown in this case, and I represent the appellant. And the background is that Mr. Abdurahman, the appellant, was convicted following a trial before His Honoured Judge Worsley at the Crown Court in Kingston upon Thames of assisting an offender with intent to impede his apprehension, which was count 12 on the indictment. And there were also 4 counts of failing to disclose information about acts of terrorism, which were counts 16 to 19 on the original indictment. He was sentenced to a total of 10 years imprisonment, which was subsequently reduced to 8 on appeal. An appeal against his conviction on the grounds of the inadmissibility of a confession witness statement was granted leave but dismissed by the Court of Appeal in November 2008. However, on the 13th of September 2016, the Grand Chamber of the European Court of Human Rights ruled by a majority of 11 to 6 that the admission of the confession statement breached Mr. Abdurahman's Article 6 right to a fair trial. Consequently, the CCRC have now referred the matter to the Court of Appeal pursuant to Section 6 of the Criminal Appeal Act 1995. It is respectfully submitted that in the light of the ruling of the European Court of Human Rights, the Court of Appeal should now find the appellant's conviction unsafe and quash his conviction. The facts are that on the 21st of July 2005, 2 weeks after the notorious 7/7 bombings of the London Transport Network, there was a second set of unsuccessful attempted bombings of the London Transport Network. In due course, 4 people, including Hussain Osman, were convicted of conspiracy to murder with respect to this second set of attempted bombings. The appellant and his co-accused Sharif Wabi Mohammed and Muhyiddin Ali were alleged in a second trial to have assisted Osman following the bombings, which was count 12. Further, the appellant was alleged to have information relating to the bombers which he had failed to provide to the authorities between the 20th and the 29th of July 2005. More specifically, following the bombings, Osman escaped to Brighton on the 21st of July 2005 and returned to London 2 days later. And on the 26th of July, he departed from Waterloo on the Eurostar, having bought a ticket issued in the name of A. Sharif. It was alleged that the appellant had harboured Osman at his house following his return to London, and during this time he not only provided Osman with food and clothing, but also ran errands for him, such as collecting his passport from his co-accused Abdul Sharif and collecting a camera used to record suicide videos from his co-accused Wabi Mohammed. Though the appellant declined to give evidence in his defence, the appellant's case at trial was that although he had allowed Osman to stay briefly at his flat and had run some innocent errands on his behalf, he had not believed Osman to have been involved in the bombings at the time, as he had not recognised Osman from the indistinct photos of the suspect contained in press reportings of the bombings. The appellant was a man of good character and without any links to extremist materials. The issue at trial was therefore the appellant's knowledge and intent. The critical evidence on this issue came from what has been called the confession statement by the CCRC. Now, the circumstances in which the statement were taken was on the 27th of July at 5:30 p.m. The appellant was stopped by Detective Constable Stewart and Vernon as he disembarked from a bus in Kennington. They told him that they were investigating the bombings of the 21st of July and had reason to believe that someone responsible had been staying at his address. He gave the officers his correct name and address and agreed to accompany them to the police station. Over the course of that night into the early hours, he provided a witness statement and allowed his home to be searched. The officer started interviewing the appellant as a witness at 6:15 p.m. However, after a little under an hour, the officers suspended the interview as they became concerned that the appellant was incriminating himself and therefore ought to be interviewed under caution as a suspect. However, when they sought the views of a detective superintendent, they were instructed to continue interviewing the appellant as a witness. As the Court of Appeal concluded in the subsequent appeal at paragraph 38, the way the police behaved is undoubtedly troubling. It was clear, and this was a clear and deliberate instruction to ignore the code. As the European Court of Human Rights noted at paragraph 299, no record of the rationale for this decision was made, and no explanation has ever been provided, or indeed by the senior officer in the case or any senior officer for this decision. Consequently, between 1:30 and 5 a.m., a witness statement was taken from the appellant. By this time, the statement was signed. The appellant had been interviewed for almost 12 hours without any significant break. The officers recalled the appellant making no amendment to the statement before he signed it. At no time during that period was the appellant ever cautioned or offered legal representation. In fact, the officers accepted in the voir dire at trial that they had given the appellant the impression he would be able to leave once the statement was completed and that he would be going to court as a witness. No recording or record of the interview was made, save for the witness statement signed at 5 a.m. Having completed the witness statement, to the admitted surprise of the officers, they were then instructed to arrest the appellant, at which point he was cautioned for the first time. Having finally been provided with legal representation, he was then interviewed as a suspect and under caution over 4 days from the 30th of July 2005. Throughout these interviews, he effectively answered no comments save for providing a prepared statement. In the witness statement, the appellant described a chance meeting on the 23rd of July 2005 at Clapham with Osman, whom he knew and refers to throughout as Hamdi. He explained that Hamdi accompanied him home, and once there, Hamdi identified himself as the fourth bomber, shown in a news report. The appellant stated that he did not believe him. The picture did not look anything like the man I was sitting next to. However, although it does not state it in terms, it is submitted that he went on to make it clear that he quickly came to believe that Hamdi was in fact one of the bombers. He states, as Hamdi began talking further about Islam, he became quite extreme with his views, and it began to sink in that he was serious. He said things like how it was right to kill yourself and other people in the name of Allah. I asked him why he had done this act. He replied, it was because of Allah. It is only right to kill myself in the name of Allah. He explained that by committing the act, he would be granted an immediate place in heaven and not to have to pray 5 times a day, to do Hajj and not sin. I asked him why he was doing this. I was starting to become quite frightened by Hamdi. All I wanted to do was to get him out of my home. Then he asked me if he could stay for a maximum of 2 nights, and then he would be on his way. I was very scared and had to give in to his requests. I realized that this man had changed from the Hamdi I had known, and I feared for my personal safety. He was obviously desperate, and I did not want to upset or agitate him, as he was obviously capable of killing. The appellant described observing an injury to Hamdi's leg, which he explained had been caused in his attempt to escape following the attempted bombing. The appellant also recalled Hamdi providing a detailed description of the planning for and the execution of the attempted bombings. He never suggested, after his initial skepticism, that he did not believe Hamdi. In short, it submitted the overall effect of the witness statement is clear, namely that he believed Hamdi had been involved in the bombings as he claimed, and he agreed to shelter him solely out of fear. In the prepared statement, it's right to say that he adopted the witness statement and stated that he had agreed to assist the police in every way possible. I gave as much detail as possible about somebody known to me as Hamdi. However, it's submitted he went on to directly contradict the witness statement on the central issue of his belief as to whether Osman had been one of the bombers. He stated, "I would like to emphasize that the CCTV video image of Hamdi released to the media was unrecognizable to me as being an image of him, and when Hamdi first claimed knowledge of and participation in these events, I did not believe him, nor did I believe him to be involved until I was stopped by the police on the evening of the 27th of July. The CCTV images look absolutely nothing like him, and I thought he was claiming responsibility for something which I thought, from my previous knowledge of him, he would have been totally incapable of doing." The appellant also corrected a number of minor details in the witness statement. For example, he said the statement is incorrect in stating Hamdi used to have a long beard and moustache. I've never seen him with that, and I don't think I said that. I intended to say that I've never seen him with a long beard and moustache. On page 2, it's recorded that I said I had noticed Hamdi was clean-shaven. I never said that either. It was 5 a.m. or so when I signed the statement, and I was very tired, having been assisting the police voluntarily since 6 p.m. the previous evening. I further notice at page 4 the words, "He asked me to look after the door." This was never said by me and is untrue, and I don't know how it had come into my statement, but was overlooked by me for the same as above. Now, the other evidence. At trial, before the contents of the appellant's witness statement, beyond the contents of the appellant's witness statement, the prepared statement, the prosecution relied on a patchwork of circumstantial evidence. First of all, there was CCTV footage showing the appellant in the company of Osman on the evening of the 23rd of July at Clapham Junction railway station, Vauxhall railway station, and walking in the direction of the appellant's flat. There was cell site evidence consistent with Osman and the appellant being in the vicinity of the appellant's flat during the period in question. A copy of the Daily Star newspaper recovered from a waste paper basket at the appellant's address bore the appellant and Osman's fingerprints and contained reporting of the failed bombings and pictures of the suspected bombers, including Osman. However, the appellant's fingerprints did not appear on pages containing reportings of the attempted bombings. Osman's fingerprints were also recovered from a glass in the appellant's home, and items linked to Osman, including his train ticket from Brighton and keys to a vehicle he had abandoned, were also recovered from the flat. CCTV footage showed the appellant collecting an object said to be a video camera used to record the bomber's suicide messages from his co-defendant Mohammed on the 25th of July 2005. Telephone evidence showed unexplained contact between the appellant and his co-defendant Sharif, and cell site was said to demonstrate a meeting between the two men, that a meeting between the two men had taken place. On the 26th of July 2005, surveillance officers filmed the appellant and a man who was later identified as Osman, but whose identity was at the time unknown. He left the appellant's address and walked to a bus stop with Osman alone, where Osman alone boarded a bus to Waterloo Station in order to, it transpired, to leave the jurisdiction on Eurostar. And then there was billing data indicating that Osman had spoken to the appellant twice by mobile telephone on the 26th of July 2005 and twice attempted to call him on the 27th of July 2005 from Italy.
Mr. King, we obviously, if it assists you, we have read very carefully the skeleton argument, which you're now reading from, that has been produced by you, and indeed that produced by Mr. Mably, the decisions of the Fourth Chamber and the Grand Chamber and the papers which the parties have submitted to us. So it's not necessary for you to read out what we've already read.
Well, so shall I? Well, apart from my skeleton argument and the submissions I've made there, I've nothing else really to.
You don't want to refine it into any submissions, for example, on the law, but it seems to me that if we can read what's in the document you've produced,
yes.
And indeed we have read it.
Well, I mean, essentially, in my submission, the potential or the areas are whether or not the decision by the European Court of Human Rights, whether in making that decision they appreciated, as it were, or had full appreciation of the domestic law and the procedures within the domestic structure. And in my submission, they clearly had, because if one looks at the document from paragraphs 274 and 304 to 310, they clearly had a very thorough understanding of the procedures, both of the investigative type procedures and also of the court procedure. So any argument to suggest that there was, they lacked an appreciation of what and an understanding of the domestic structures and legislation and procedures, in my submission doesn't stand up to scrutiny. Because there were three other applicants before the court at the time, and in their cases, they had been provided with a safety interview. And of course, the European Court looked at all of that, and there was an argument at the time that safety interviews actually breached the Article 6 rights. But the court decided that wasn't the case, that there may be compelling reasons sometimes to override even very fundamental rights, but there has to be a structure and procedure in place in order for that to be done. Otherwise, we end up effectively with executive lawlessness. So, and of course, there were some, there are occasions when perhaps minor breaches of procedural rights will be ignored. And indeed, in that case, they talked about where the wrong caution had been given, for example. And that didn't wash with the court, because although it was a breach technically of a procedural right, the key thing was the person was informed that he was a suspect, and he was made aware of his right to silence. So there are occasions, and so again, in my submission, the court had a very detailed appreciation of the procedures in place, and indeed effectively gave gave support to the structure that had been put in place in relation to terrorist offences, namely the concept of safety interviews. But in the case of the appellant, The reality is there were no structures in place to enable the police to do what they did. Because they realized he was a suspect when he started to incriminate himself after an hour. The two officers in the case then phoned their superior, who told them, continue interviewing him. Those two officers accepted at trial that their understanding of that instruction was that he would be released at the end of the process because he would be a witness.
Does the does the absence of a precise procedural provision covering a particular situation inevitably make the trial unfair, or does it depend on the character of the...
It depends on the character of the breach, how serious the breach is, and also looking at the case holistically, looking at the case as a whole. And the European Court took the view that the cumulative effect, as it were, of the various breaches made the thing a breach of Article 6.
So what was it about the characteristic of the absent direction in the rules governing this particular situation that you say makes this unfair? It's an unfair trial.
That when a person becomes a suspect in a case where he is being interviewed by the police, to then continue to pretend to that person that he is a witness. And again, the officers accepted that they were misled by their superior, and they could well have misled the appellant.
So it's the absence of a rule directing police officers what to do when a witness becomes a suspect.
Correct. That's the first thing that there is no rule which says, I mean, the general principles are that when a person is a suspect, he has certain rights, namely to be cautioned and all that. Now, those rules were not observed, and there are no other rules within the structure which allows the police to continue to interview a person as a witness when they become aware he's a suspect. And there are no rules which allow the police to continue to interview someone as a witness when they know he's a suspect and have conveyed to him the impression that they are continuing to interview him as a witness.
If there was a rule that permitted precisely that, so in other words, there was a provision written down in the code to that effect, would that make the trial fair if that was complied with and the interviewing of the person who become a suspect was to continue? What I'm really asking is it the absence of the rule that matters, or is it the underlying conduct?
Well, it's a bit of both. I mean, in the circumstances that it's highly unlikely in my submission that in a democratic structure, there would be either by way of court rules or to allow that situation for a person who is a witness to be who becomes a suspect to effectively be misled about his position. So the whole idea that could ever become a rule, I think, is doubtful. But assuming that there were that rule in place in the domestic law, it would still be open to the European Court to say that rule itself is unfair.
What one's looking at is the underlying...
It's the underlying position where the person is a suspect, has become a suspect, and they continue to interview him as a witness and convey that to him in the process.
The fourth chamber and the minority in the Grand Chamber, to sum up their view of the focus of the majority of the Grand Chamber on this procedural issue and the fact that there was a breach of the code, was that there was a failure to see the wood for the trees, and that this obstructed the view that as a matter of law should be taken of fairness, which is at the end of the whole process, ending with conviction, is to look at the matter holistically. In other words, one has to have regard to what happened during the course of the trial, as well as what happened pre-trial.
Yeah, well, that was the minority view, but the majority view was that what happened in those circumstances breached his rights and made the trial unfair. And that is the decision of the court, ultimately, despite the dissenting judgments.
We have to make our own decision about the safety or not of the conviction.
Indeed.
We have to have regard to the decision of the Grand Chamber, but we're not bound by it.
Well, that's correct, but as Lord Wolfe says, there are very few circumstances when there's such a fundamental breach of human rights that the court will find that it's not that the trial is fair.
Do you want to take us to the passage
Yeah.
you rely on?
It's in Toker, which I think is the second authority that can pay at paragraph 30. As a matter of first principle, we do not consider that either the use of the word unsafe in the legislation or the previous cases compel an approach which does not correspond with that of the ECHR. The requirement of fairness in the criminal process has always been a common law tenet of the greatest importance. The common law approach has been enhanced by legislation, and in particular the Police and Criminal Evidence Act 1984, and the codes of practice made thereunder, sections 66 and 67. Fairness in both jurisdictions is not an abstract concept. Fairness is not concerned with technicalities. If a defendant has not had a fair trial, and as a result of that injustice has occurred, it would be extremely unsatisfactory if the powers of the court were not wide enough to rectify that injustice. If, contrary to our expectations that not previously been the position, then it seems to us that it is a defect in our procedures which is now capable of rectification under Section 3 of the Human Rights Act 1988. The 88 Act requires primary legislation and subordinate legislation to be read and given effect to in a way which is compatible with convention rights. Section 6.1 of the 1998 Act makes it unlawful for a public authority to act in a way which is incompatible with a convention right, and a court is a public authority for the purposes of Section 6. The 1998 Act emphasizes the desirability of taking a broader rather than a narrower approach as to what constitutes an unsafe conviction. In Davis and Rowan Johnston, the court acknowledged that there could still be a distinction between its approach and the approach of the European Court of Human Rights. However, in the later case of Francom, this court indicated in a judgment which I gave on behalf of the court that we would expect, in the situation there being considered, that the approach of this court applying the test of safety would produce the same result as the approach of the European Court of Human Rights, applying the test of lack of fairness. We would suggest that even if there was previously a difference of approach, that since the 1998 Act came into force, the circumstances in which there will be room for a different result before the court and before the European Court because of unfairness based on the respective tests we employ will be rare indeed. Applying the broader approach identified by Rose, we consider that if a defendant has been denied a fair trial, it will almost be inevitable that the conviction will be regarded as unsafe. For this reason, we adopt the approach of Rose and Mullen and prefer the broader approach to the narrower approach. It would be right to stop a prosecution on the basis that there was an abusive process. The court would be most unlikely to conclude that there was a conviction. Despite this fact, the conviction should not be set aside. So that is a flavour in my submission of the approach that this court should adopt when looking at the decision of the European Court.
Is there any other authority you would invite us to look at on that topic?
There are later authorities dealing, aren't there, with the proper approach of the domestic courts to Strasbourg authorities, and in particular there's the proposition that domestic courts are required to follow a clear and consistent line of Strasbourg authority on a particular point. I think that comes from the case of Pinnock. So is it your submission that the Grand Chamber's decision here represents a clear and consistent line of Strasbourg
Indeed,
authority?
Yes.
Where is that clear and consistent line?
Well, if we look, for example, at the judgment in Anderson, at paragraph 18 of Lord Bingham's judgment, we see that it was argued for the Home Secretary that the House of Lords that should not follow the judgment, which was criticised as erroneous and lacking in reasoning to justify and explain the court's departure.
Are you reading from this authority?
Yes, Your
Could you give us the paragraph number, please?
Yeah, it's paragraph 18 as Lord Bingham's judgment in Anderson.
Yes, I'm in the right case. I just want the paragraph number, please. Paragraph 18.
Paragraph 18, it's
Thank
in
you.
Lord Bingham's.
Thank you.
I cannot accept this argument. While the duty of the House under Section 2.1 of the Human Rights Act is to take account of any judgments of the European Court whose judgments are not strictly binding, the House will not without good reason depart from the principles laid down in a carefully considered judgment of the Court sitting as a Grand Chamber. Now, this is a perfect example in my submission of that scenario where the court has sat as a Grand Chamber, has very carefully considered all aspects of the case, from investigation to appeal, and has come to a conclusion.
What do you think are meant by the words "without good reason"?
Well, I suppose that would be situations where the court considered that there were good reasons, but what those would be, I don't think, I don't recall. Well, in any event, my submission is in this particular appeal, there wouldn't be good reason to depart from it, because it's clear what the domestic law is. It's clear that the European Court have carefully considered the procedures and structures, have distinguished the safety interviews, and have come to the conclusion that there is a fundamental breach of a human right. And likewise, in the case of Dundon, which is again a paragraph 12, in our judgment, it's not appropriate to seek to construe the judgment of Greaves as if it were a statute. Whatever comments can be made in relation to the detail of the court's reasoning, the leitmotif of the judgment repeatedly shines out in the paragraphs 82 to 80 and 91. This is a situation where there was the pivotal role of a naval judge was performed by a serving naval officer, not a civilian. So that's a bias type case. But then in paragraph 15, it goes on to say, in many cases, breach of an Article 6 right will not result in quashing of a conviction as unsafe, but that is not necessarily the result.
I think you read that incorrectly. There's no "not" there. In many cases, breach of an Article 6 right will result. You inserted the word "not."
Yeah, but that is not necessarily the result. Not necessarily the result in all cases, as per Lord Wolfe in Toker and Lord Slynn. In every case, the outcome depends on the kind of breach and the nature and quality of the evidence in the case. Just and proportionate satisfaction may, in an appropriate case, be provided, for example, by a declaration of a breach or a reduction in sentence rather than the quashing of a conviction. Breach arising from delay may be one such consequence, and there may be other exceptional cases in which a conviction may not be unsafe. For example, if there has been unfairness because of a legal misdirection, but the evidence is overwhelming, or possibly if the trial is unfair because of an inadequate prosecution disclosure on a peripheral issue. And going back to my Lord's question, maybe those are the sort of things that would a good reason would apply. So in other words, it depends on the type of breach and the overall circumstances of the case. And in other words, the seriousness of the breach is important. If it's some peripheral issue, for example, disclosure of something that didn't make much difference, or if the evidence is so overwhelming that even a fundamental breach potentially may not apply.
I don't want to take you out of your course, Mr. King, but are you at some stage going to address that latter question as to whether or not there was overwhelming evidence in support of this conviction?
Yes, indeed.
I'll leave you to do it in your own course then.
Yeah. Unless there are any other areas of this particular topic, which in my submission is that eventually this is the sort of breach that this court must take account of, and it cannot really, that there is no conceivable circumstances in which there could be a good reason could be given for essentially treating someone as a witness, deceiving them as to their status, and not cautioning them, but continuing to extract information from them that brings about essentially a statement on which they incriminate themselves. There couldn't be a good reason for allowing that scenario to occur.
You would say this is not an exceptional case on the facts as they applied on the day in which these events occurred?
Yeah, I would say the facts are exceptional, there's no doubt, no doubt about it, but there was in place a procedure to deal with exceptional circumstances, which was dealt with by the other applicants at the European Court, namely safety interviews. And they are applied in exceptional circumstances. So we have a procedure for dealing with exceptional circumstances.
Would there be a parallel of a safety interview in the sort of circumstances that apply to your clients, namely where during the course of an interview as a witness he reveals material that might cause him to be treated as a suspect? Would it be acceptable in that situation to apply an equivalent of the safety interview?
Well, in my submission, he should have been given the safety interview because there was a procedure in place to do that, and he wasn't. And that's the point that the European Court makes.
So they should have stopped the interviewing as a witness, cautioned him, allowed him to obtain legal advice.
Well, they don't have to provide legal advice at that point. They can continue to interview him without legal advice, but they've cautioned him. And in order to, if there's a serious situation, in order to get information quickly without access to a lawyer.
Yes, I see. Thank you.
So, and that's the point here, that there were in existence within the domestic regime a procedure to deal with exceptional circumstances envisaged by terrorism.
Are there any particular paragraphs of the decision of the Grand Chamber that you would wish us to have regard to? You don't need to read them, but what particular paragraphs do you rely on?
It's difficult always to pick out individual things. Someone said to me one time, give me the gist of something, and the answer was, well, it's all gist. It's a bit like that with this. But if we could look at
it's a very detailed read.
Yeah,
there are
certainly 137 to 179, where in my submission they take us through a detailed analysis of the entire procedure from the police interviews as a witness, then the giving of his witness statement, the interviews and statements as a suspect, then the trial, the admissibility of the witness statement, and then they deal with other prosecution evidence, the abuse of process application at 163. So on this point, it's basically from 137 right up to 179. And then at 181, they deal with the relevant domestic law and practice. And at 186, talk about safety interviews, which I've been addressing the court on. So, and that would go from 181 up to 202. And then from 295, where they talk about compelling reasons, which deals with the point your ladyship made about exceptional circumstances prevailing at the time. and then 299. And then 301 to 311 deal with the fairness of the proceedings as a whole, looking at the holistic, taking a holistic approach.
Could you, in that regard, help me with the last paragraph of 310, please?
Yes.
Court considers the trial judge's directions left the jury with excessive discretion.
Yes.
What do you say about that?
Well, my Lord, if I can just find it in my skeleton, I have dealt with it. Essentially, I would, in my submission, this does indicate the detail that the court, or the level of detail that the court went into and the understanding of the case, because the trial judge used the word they were to take into account, but the practice direction, or the book, bench book direction says may take into account. For example, a small thing like that.
Just in relation to that, there may be an answer in the papers, but on the directions that were given to the jury, was there a discussion with counsel or beforehand, and was there a correction asked for afterwards by counsel in relation to the directions that were given? Because our process allows for...
It's so long ago now, and I can't...
But our process does allow for that if it is thought that there is a material misdirection by the judge.
Yeah, I mean... I can't recall ever noticing that, to be honest, that there was, and in a way, in my submission, this aspect of it is not, it's one small aspect of the cumulative, in my submission, they're not wrong about the fact that there was a potential too wide a direction given by the trial judge.
A curious word to use, discretion, Mr. King.
Sorry,
a curious word to use, discretion.
Yeah, I'm just trying to find it, my lady. Yes, it's a paragraph 4.8 of my skeleton. 4.7 and 4.8. While the European Court were not critical of the jury direction as a whole, but just the following sentence, which appears on page 15 of the transcript of the summing up. If you are sure that despite the breaches of the code, the statement was freely given in the sense that he would have said those things whether or not he was cautioned, and even if all the rules in the code had been followed and it was not true, and that it was true, then you will take it into account when considering your verdicts in relation to Abdurahman. In fact, we say that this direction deviated from the conventional direction. First, the jury were not directed that if they consider there was or may have been a breach of the code, they must consider the effect that this may have upon the reliability of the confession and the weight they attach to it, as suggested in the Crown Court Compendium. The impact of the material misdirection was compounded, submitted, by the fact that the jury were directed that they will, rather than may, take the statement into account when considering the verdicts, as per the specimen direction. So finally, the jury were not directed that they should only rely on the confession if it would be fair to do so, as per the specimen direction of the Crown Court Compendium.
This sounds like a pure domestic error that you're alleging here, whereas what the European Court is looking at is whether too much latitude was given for the purposes of Article 6.
Well, in other words, taking the direction as a whole rather than looking at specific...
Well, this appeal is based on a reference which itself is based on the judgment of the Grand Chamber, isn't it?
Yes, indeed.
So really what we're looking at is whether what's in the Grand Chamber's judgment is a sufficient basis for the appeal. And the point you've just made is a point, isn't it, that could have been made first time round to the Court of Appeal?
Yes, indeed, but that's only one, and to the best of my recollection, that point wasn't made. But having said that, this is only one aspect of the cumulative effect of the unfairness that emanates from a number of procedural and substantial breaches of his human rights, of his rights as a defendant or as a suspect.
Forgive me. My concern was to understand whether you were saying that in that paragraph, the court, the Grand Chamber, was accurately summarising the effect of English law, or are you saying that this was an error of law when viewed through the spectacles of the Convention? I mean, as my lady said, the reference to excessive discretion is a curious one when describing what a jury does, isn't it? And it raises the question whether the court has accurately understood the function of a jury. Well, juries don't exercise discretion, really, do they? They come to judgment on the facts.
Yes, but they're given directions as to what the parameters that they must abide by in terms of making a decision.
You would say this, perhaps a better word might have been latitude.
Yes, it's latitude.
It's really the word
In fact, that is the word that's used in the French text, latitude.
Or maybe it's a bad translation.
Well, English was the language of the case, so...
Yeah. I have to confess I haven't read the French text, not being competent enough in French to do that. My Lord makes the point that perhaps that is the point, is latitude. And then finally, a paragraph up to, so I'm inviting the court to look at, from effectively from 295 to 311, in which the court goes on to say in 311 that they accept the nature of the offences have to be of the offences in this case were serious, and great weight must be attached to that. And while they were not of the magnitude that were of the offences of the first three applicants, the threat posed by terrorism can only be neutralised by the effective investigation, prosecution and punishment of all those involved in terrorism. However, taking into account the high threshold which applies when the presumption of unfairness arises, and having regard to the cumulative effect of the procedural shortcomings in the fourth applicant's case, the court considers that the government have failed to demonstrate why the overall fairness of that trial was not irretrievably prejudiced by the decision not to caution him and to restrict his access to legal advice. There was therefore been a violation of Articles 6.1 and 6.3. So those are my submissions in relation to that aspect of the case, and in my submission, therefore, that confession should not have been admitted before the jury, which then leaves us to the issue that Your Lordship raised, that well, what is left and whether what is left is has to be overwhelming. The evidence would have to be overwhelming in order for this court to say that the conviction would be safe. And in relation to that, in my submission, there is insufficient evidence on which a jury properly directed could, or certainly would find that the appellant had knowledge. The remaining evidence in my submission amounts to association.
You include in that evidence the evidence of Mr. Osman.
Well, of course, the evidence of Mr. Osman, on any view, would be taken with a degree of care, that he was giving evidence on behalf of his brother. He was already a convicted terrorist and had an axe to grind, as it were, in terms of trying to extricate his brother from the situation he found himself in.
And Mr. Sharif, you would say the same? But
and it's the same, what weight can really be given to a co-defendant in a cutthroat type scenario, and likewise to the brother of a co-defendant who's already a convicted terrorist.
How would the evidence that your client had collected the passport assist Osman or his brother?
I suppose it would be that if they could make Osman's already convicted, and he's the one who went to Rome and all that on the passport. But if they could shovel as much blame as possible onto Abdurahman, the appellant, then clearly the more they could discredit him, as it were, potentially exonerates Sharif, the brother. So this would be another way of doing it, because it matters not now in terms of the Osman's escape, because it has occurred, and of course it was also Sharif.
Sharif was a co-defendant with your
Yeah,
client.
he was a co-defendant with my client. That's right. So, in Sharif, in trying to distance himself from knowledge of why he was giving the passport, by blaming the appellant as being the person who was orchestrating all of that, was helping him, because it was distancing him from knowledge.
Did Sharif say that your client was orchestrating matters, or was he just picking up the passport and delivering it to Osman?
Well, I need to check on that in the...
I'm simply trying to understand what you say the significance is of the fact that it was Sharif and Osman giving evidence about the collection of this passport.
Yeah. My recollection is that Sharif certainly, it did help Sharif's case if my client shouldered the blame, as it were.
Well, plainly, yes, but I'm asking about the particular evidence relating to the passport.
Well, clearly, if he had gone to take a passport from him, and Sharif didn't know that, or was given the... Now, I'm being sketchy on this because I can't really remember the conversations, or whether there were conversations between Sharif and him at the time. But I do recollect that Sharif was wanting to distance himself from any knowledge, and therefore, potentially, the knowledge that Abdurahman had about the reasons for doing it were going to assist him.
Thank you.
But I can't recall the exact nature of his defence at this stage, nor the communication that occurred. But my general understanding of and memory of it is that Sharif was distancing himself from knowledge, but heaping knowledge onto Abdurahman. And that passport then, the critical document to get him out of the country, if it was Abdurahman that was supplying that rather than Sharif, as it were, then that assisted Sharif.
There was nothing about the passport in the witness statement, was there?
No, it wasn't.
The evidence about the passport was entirely independent of the error that you're relying on.
Yes, of course, but of course, we don't know the entire of what was discussed in those 8 hours, or nearly 12 hours. We don't know whether the passport was mentioned. It's not in the witness statement, but as your Lordship will see, the witness statement is very short and it could not possibly reflect what was discussed in the entire period that he was with the police or was being interviewed. And we don't have a record of that, so we don't know whether any of that was actually mentioned or what other areas were discussed. And that's one of the difficulties with lacking, where again the procedure is lacking, because there was no recording. And of course we all know why the Police and Criminal Evidence Act came into being, so that we have clear records of what occurred. We don't have it here. And it's a very small, in relation to obviously what must have, the discussions that went on throughout that night, it cannot, in my submission, be reflected properly in a statement that's been compiled by the police officers after a very lengthy period of discussion or in interview with the appellant. So, again, that, in my submission, there would be, both Osman and Sharif had ulterior motives for saying what they said in relation to the appellant. The rest of the evidence amounts to CCTV footage, which shows the appellant in the company of Osman in the evening of the 23rd at Clapham Junction. Now again, it's clear that this was a chance meeting. There were no phone calls between Osman and him prior to that meeting. There was no evidence and no evidence that the appellant was involved in any group to prepare for these potential bombings. There's no evidence of any communication with any of the other co-defendants prior to that meeting. And of course, there is no evidence of any material within his possession or that he viewed in any way related to terrorism. So this is a person who clearly he was not part of a terrorist group or a group that had issues with regard to any acts or any violence or anything of that nature. There's just nothing in the background at all that can suggest otherwise than this was a chance meeting. And he, therefore, it's basically association. This shows. It does show that he was at his house. The cell site evidence was consistent with Osman and the appellant being in the vicinity of the appellant's flat during the period in question. Now, a copy of the Daily Star newspaper was recovered from the basket at the appellant's address, and it bore the appellant and Osman's fingerprints and contained reporting of the failed bombings and pictures of the suspected bombers, including Osman. However, the appellant's fingerprints did not appear in pages containing reporting of the attempted bombings. Now, this, of course, this material was obtained by a search of the appellant's flat in circumstances where he had agreed to allow the police to go to his flat. But it was after the point at which they became aware he was a suspect. Now, theoretically, that search, therefore, was an unlawful search. And this evidence, any evidence, therefore, from the property could be potentially excluded from a trial because it's the product of an unlawful search.
Was that a point made to the trial judge during the trial? Was there an application to exclude it?
No, because the trial judge allowed the statement in.
Was it made to the Court of Appeal?
Well, at that stage, we were not arguing as to what other evidence might remain. We were arguing that the confession itself rendered the trial unfair and therefore should have been overturned at that point. So those, the main thrust of the Court of Appeal and indeed the European Court applications had to do with the whole business of the witness statement, how it was taken, the circumstances of that. That's where the unfairness lay. So we didn't have to deal with the issue of whether, if you remove that, there would be sufficient evidence to convict at that point.
It would be surprising if the point wasn't made, because one of the issues the court always has to consider in relation to the admission of evidence, if it's said to be wrongly admitted, is the question of the overall safety of the conviction, which would depend upon what other evidence was legitimately before the jury.
Yes, but of course, if the defendant, if the appellant's statement and interview have been correctly admitted, as the Court of Appeal held they were, then any subsequent, any follow-on from that would also be admissible. So it would be difficult to argue that they were inadmissible in view of the fact that that it was before the jury that he had given permission to them to search his flat.
Looking at the decision of the Court of Appeal, it appears that the points that you made on behalf of the appellant were confined to the admissibility of the statement and the argument that the judge was wrong to refuse to stay the proceedings was an abuse.
So
It is, yes. It's in our bundle at, difficult to point you to where it is.
there are page numbers, I think, at the bottom of the judgment.
Yes. There's paragraph 37 and 39.
My lady, I'm sorry, my copy doesn't seem to have paragraph numbers, but it has page numbers at the bottom. I don't know. The lady would be able to say which page.
Does it have the report of the decision has no paragraph numbers? Did you say?
Oh no, sorry. It's the sorry. I thought you were talking about the judges summing up. It's the
No, I was looking at the decision of the Court of Appeal in November 2008.
The paragraph that begins, the way the police behaved was undoubtedly troubling.
Yeah, that's 38.
It's 38.
It's 37. Did I say 37 and 39?
Yeah.
At all events, there's nothing recorded there as to the of any submission by you that one consequence of the introduction of this material, which you said should not have been introduced, was that the remainder of the evidence was tainted.
It looks as if I missed it. I mean, clearly at that stage we were very much focused on
Yes, I follow.
the whole business of the key
Yes.
area was the taking of the witness statement, the lack of caution, the lack of, and the situation in which a person was being told, and he was a witness, but in fact when the authorities knew he was a suspect, and they continued to convey that impression to him in the course of the continuation of the interview. But from that decision of the Court of Appeal, and of course my submission is that even if we had raised those sort of issues, it would have made little difference, because the key document or the key evidence was the admission of his confession. So arguably now we're at a position where if the confession itself is inadmissible, then the issue then arises as to what's left.
Yes.
And whether that amounts to overwhelming evidence of his guilt.
Was this issue raised before Strasbourg? Because the courts in Strasbourg did look at the remainder of the evidence.
Yeah, they did look at it.
Apart from the witness statement.
Yes, certainly they
I mean, in paragraph 217 of the fourth chamber, fourth section, say, they refer to the evidence apart from.
Yes, and in fact, in paragraph 308 of the judgment of the Grand Chamber, there's reference to
223 in the Chamber judgment.
223.
In this fourth section judgment.
Yes, where it's 308, I think, does. It's true the prosecution also relied on other evidence in the case. The fact that he met Osman and the two returned together to the fourth applicant's flat, spent 3 days there, were demonstrated CCTV evidence, meeting and walking towards the police surveillance camera showing the two men.
It doesn't look as if from that the point you're now raising was raised before the Strasbourg court.
No, I'd agree. But I think at some point in the Strasbourg judgment, just from memory, I think they do mention the fact that if the key evidence is excluded, then potentially other evidence is tainted. I'm not sure if I can find it. But.
There's a mention at 309 of the fact that the statement provided the framework around which they subsequently built their case. Is that what you're referring to?
That's what I was thinking about, yeah.
But they do go on at 315 to say absolutely explicitly that
yes, they do say that it's impossible to speculate as to what might have occurred had there been no breach of the convention.
yes.
And of course, that's what, you know, and they made it clear that they were not saying that the conviction was either safe or unsafe. They were saying there is a breach of his rights, and it's a matter now for this court to decide whether the conviction is safe or not. And in my submission, the remaining evidence would be far from overwhelming in terms of establishing the knowledge and intent of the appellant. would essentially prove association, and it would be highly unlikely that a jury would convict on the basis of evidence from a convicted terrorist brother or the brother of who had been convicted, and the co-defendant who was in a cutthroat situation trying to exonerate himself in a multi-handed trial. Those are my submissions, my lady.
Thank you very much. Yes.
May it please, my lady, the question in the appeal is whether or not the finding of the Grand Chamber should lead to the conclusion that the convictions in the appellant's case are unsafe within the meaning of the Criminal Appeal Act. May I, at the outset, set out the 5 essential submissions on behalf of the Crown. First of all, as a matter of principle, the finding of a violation of Article 6 in Strasbourg, or indeed the finding of a violation of Article 6 by a domestic court on review, does not automatically lead to the conclusion that a conviction is unsafe. Secondly, whether or not a conviction is unsafe depends on the nature of the breach and the facts of the case, and that must be analysed on a case-by-case basis. Thirdly, in the appellant's case, his trial was not unfair, having regard to the compelling reasons for taking the witness statement. In the circumstances. The fact that he adopted that statement under caution, and the fact that the way the statement was treated in the trial proceedings was subject to a number of very important procedural safeguards which were not given sufficient weight by the Strasbourg court. Fourthly, the decision of the Grand Chamber that there was a violation did not involve a finding that the conviction was unsafe. It did not amount to a finding that the witness statement was inadmissible, or that having regard to the other evidence in the case, the conviction could not be justified. Put simply, the question of safety was simply not assessed by the Strasbourg court. And fifthly, even if, taken at its highest, the finding in Strasbourg would lead this court to conclude that the witness statement ought not to have been admitted, the fact is that the other prosecution evidence in the case was overwhelming, it established the key facts of assistance given by the appellant and established them on, in most cases, an incontrovertible basis. And that gave rise to a very strong inference of guilt, and in particular, an inference of a guilty state of mind. And it is also the case, in relation to the evidential picture, that the evidence called on behalf of co-defendants destroyed the appellant's case. And in those circumstances, approaching the question of safety on the basis that the statement ought not to have been admitted, it nevertheless remains that the only reasonable verdict was a verdict of guilty, and the conviction is therefore safe. May I say something, first of all, about the charges that the appellant faced? There were 5 counts. They fell into 2 categories. First of all, there was a count of assisting an offender, which was count 12. And the essence of that count was that the appellant sheltered Osman for a period of 4 days and helped him leave the country. The other 4 counts related to the offence of failing to disclose information. They were counts 16 to 19. They were, in fact, identical counts with each other. The only difference was that they related to the 4 individual bombers. But the evidence in relation to those counts was, in all material respects, the same evidence as in respect of the assisting an offender count. That was the information that the appellant was alleged to have had. It was through his assistance in relation to Osman. So the question of safety can conveniently be analysed in reference to the single count, count 12, assisting an offender. And just to say something about what the issue was in relation to that count. The count itself specified acts of assistance which had been provided. And they are set out in the judgment, in the judge's summing up, page 060 in the CCRC's submission. And that is the judge's summing up, which is internally page 8 of the summing up. And at the bottom of page 8, my lady will see small Roman numbers. 2 was provided accommodation and food. 3 was providing fresh clothing at the very bottom of the page. And over onto page 9. Item 4 on the indictment was provided the passport. And item 5 was returning the camera. And in fact, all of those, apart from the passport, which I'll come to later, were admitted by the appellant during his case. And even without that non-contest at trial, they were provable from the CCTV footage. So it was incontrovertible that he had provided shelter and the camera and so on. But just in relation to the way the jury were directed to approach those acts in count 12, on the previous page, page 7 of the judgment, of the summing up, in the middle of the page, there's a paragraph that begins, "in order to convict." What the direction that the jury were given was they had to be sure only of one of those acts. It wasn't a case that they had to be sure of each of them. They didn't have to tick every box. One of the acts would have been sufficient. So the prosecution case did not in fact depend on proving the issue in relation to the passport, which was the only contested factual issue. And the second half of that count, the state of mind, was required, and this is where there was a contest at trial. That's conveniently summarised on page 8 of the summing up. And there are two states of mind that the prosecution were required to prove. And in the second paragraph on page 8, the judge refers to question 2. You will then go on to question 2. And what the judge is referring to is the written directions that he's given the jury. And question 2 deals with state of mind that the prosecution had to prove. Abdurahman, the jury had to be sure that Abdurahman knew or believed that Osman had committed the act of terrorism. And the second mental ingredient of the offence was summarised by the judge 2/3 of the way down page 8. And it's question 6. If your answer is yes, you could go on to the final ingredient the Crown must prove, question 6. Has the prosecution made you sure that Abdurahman, at the time of carrying out the act of assistance, intended to impede the apprehension or prosecution of Osman? Knowledge or belief that Osman had committed the act of terrorism, and then the appellant acting to assist him with the intention of impeding arrest or prosecution. And the witness statement was only relevant to the first of those matters. Because in the witness statement, the appellant had said that he, over time, when Osman was with him, came to believe that Osman's claim to have been involved was true, or might be true. Later in his interview under caution, he was to say something different. He was to say, no, in fact, I never believed it. I never believed him capable of doing that. But the evidence in relation to the defendant's state of mind, in truth, came from 3 separate sources. There was the witness statement, so far as it went. But secondly, there was his police interview under caution, where independently of adopting his statement, he accepted that Osman had stayed with him. And thirdly, and most significantly, so far as the prosecution were concerned, were the inferences that were to be drawn from the incontrovertible facts in the case. The prosecution, in order to prove the defendant's state of mind, were not taking his word for it. The prosecution had evidence that he had sheltered the bomber and helped him conceal evidence and spirit his way deceptively on a Eurostar out of the jurisdiction to Italy. And in terms of proving the appellant's state of mind, the inferences to be drawn from those facts were devastating. So, in approaching the question of the witness statement and its significance and its true status in the prosecution, the Crown would frame the matter in that way by reference to the ingredients of the offence and the issues that were in fact in dispute. Can I then, my lady, move to the judgment of the Grand Chamber?
Yeah.
Highlight the key passages, and also perhaps simply to note the structure of the judgment as well in relation to the appellant. The appellant's case is discussed by the Grand Chamber at page 34 of the judgment, it's paragraph 137, where the factual position is set out at some length. And in terms of the other prosecution evidence, reference is also made to that in the factual summary at paragraph 162 on page 39. The analysis of his case begins at page 79, paragraph 295. And the first finding of the Grand Chamber is that there were no compelling reasons for the failure to caution him at the time the witness statement was being taken. And in essence, what the court found at paragraphs 298 to 300 was, whilst acknowledging that the contingency on the ground and the urgency, what had happened was the appellant had been misled by the police into thinking he was a witness and not a suspect. And that course of conduct had not been carried out in accordance with a statutory scheme, in contrast to the cases of the other three applicants before the Strasbourg court, where the delay in providing legal advice had been performed pursuant to the relevant provisions of the Terrorism Act. So that was the essence of the finding in relation to no compelling reasons. But what the court then went on to do is to analyse the fairness of the proceedings as a whole, and that analysis begins at paragraph 301. But in the submission of the Crown, it's important to note that that analysis that was carried out in a particular context, and the context was to determine, for the purposes of Article 6, whether the delay in legal advice led to a violation of Article 6, 3, subparagraph C. In other words, it was to determine whether the other factors in the case made good the shortcoming in Article 6 terms that the court had identified. And in that regard, another part of the context of that examination was, having found that there were no compelling reasons, the burden shifted to the government on the Article 6 question to establish that the proceedings as a whole were fair. There was a presumption of unfairness, and as the court made clear towards the end of its judgment, which I'll come to in a moment, the government had to overcome a high threshold once the deviation from Article 6.3c had been found by the court. So the significant point, the submission of the Crown in relation to this aspect of the court's reasoning is it is not an examination of the safety of the conviction. It is simply seeing whether the proceedings as a whole could make good the procedural shortcoming. And what the court did was to consider what had happened at the trial in relation to the applications for exclusion of the witness statement under sections 76 and 78 of PACE. That's 304 of the judgment. It considered the fact that the matter had been litigated in front of the jury, paragraph 305. Considered the other evidence in the case at paragraphs 307 to 309. I'll come back to that in a moment. And it considered the judicial directions at paragraph 310. And in the end, the conclusion at 311 was having regard to the presumption of unfairness and the high threshold which applied. The other factors didn't make good the procedural deviation from 6.3c. In other words, didn't justify that shortcoming. Now, may I say something else in relation to distinguishing that analysis from the question of safety? Because the court at 309 gave its conclusions in relation to the other evidence in the case and concluded that the witness statement had a central position in the prosecution's case. It was integral, it was a significant part of the probative evidence upon which the conviction was based. But as the minority observed, in reaching that conclusion, the majority took account of factors that were irrelevant to the question of the strength of that evidence, that other evidence. Because as was made clear during when my learned friend addressed the court, in concluding that the statement had a central position, the majority took account of the fact that it provided the first grounds on which the police came to suspect the appellant, which was irrelevant so far as the jury's assessment of the evidence was concerned, and that it provided the framework around which the prosecution built its case, again, which was another irrelevant matter so far as weighing the other evidence in the case is concerned. So what the court is doing, what the majority is doing here, is not saying that the witness statement was so important that without it, the conviction is unsafe. What it is doing is simply saying, in the context of the case as a whole, including the investigation, it was sufficiently important for that to be a relevant factor in determining whether or not there has been a violation. It's not an insignificant piece of evidence that can simply be, the court can simply say had no bearing, so insignificant that the procedural defect did not give rise to a violation.
Do you say they were wrong to do that? Because you say, well, your previous submission was that the conclusion that in concluding that the witness statement had a central position in the prosecution case, the majority took account of factors that were irrelevant to the question of the strength of the evidence. And what do we draw from that?
What's to be drawn from that is that the majority, in asking itself the question in relation to a violation of Article 6, was looking at a wider context, a wider assessment than the question of the safety of the conviction. It was looking to the way the case was investigated as well, which is not something which is relevant in assessing the strength of the other evidence, so far as whether or not it points to guilt or innocence. Now,
I'm sorry, please finish. So you're drawing a distinction between the material on which a conclusion is reached as to breach of Article 6 and the material relevant to safety of the conviction.
Exactly so.
But there is, doubtlessly you'll come to it, there is some authority to suggest that, at least ordinarily, a finding of a breach of Article 6 will lead to a conclusion of unsafety.
Well, in my submission, that's not the case, and it depends, because in the end, there are two factors. First of all, should a violation of Article 6 of itself lead to a conclusion that a conviction is unsafe? And in my submission, the answer to that is it depends on the nature of the violation. And what the authorities show is that if, for example, there is a finding that a defendant has not received a fair trial in the sense that the tribunal was not impartial, then that has to lead to a finding that the conviction is unsafe. But on the other hand, if the violation arises from, for example, a misdirection, or the admission of evidence which ought not to be admitted, or a defect in disclosure, the question is, for the court on safety, is the question that the court always asks in relation to safety, which is, would this have affected the verdict? I'll come to the precise formulation of that in a moment.
And the court in this case could have gone on to consider that issue because they had before them a claim for just satisfaction, which would have depended on a decision on that question. They declined to do that.
They did, and stated expressly. Their findings, paragraph 315, was not that he had been wrongfully convicted, and they weren't prepared to speculate. It's not their role to speculate on the safety of the conviction, and noted that he had a remedy. He could make an application to the CCRC for the matter to be analysed under the correct law and in the correct forum. So, can I turn to those authorities and see how the submission I've made is set out. And can I take the court to the case of Dowsett, which is the first case in my learned friend's bundle. Where paragraph 11 the High Court noted at the bottom of that paragraph that one of the questions that had to be resolved was the effect of the breach of Article 6 upon the safety of the conviction. And there was discussion of the cases of Forbes and Lambert, paragraphs 12 and 13, where Lord Steyne in Forbes had appeared on one view to suggest that the questions of violation and safety would have the same answer. But then in Lambert, Lord Steyne said in the quoted passage, Lambert was a misdirection case. Even if the judge had directed the jury in accordance with law, the conviction would have been a foregone conclusion. Now, Lambert was a case where the judge had directed the jury on the burden of proof in a way which the court held would have been a violation. It was a reverse burden of proof, imposing, once certain facts had been established, the burden on the defendant to prove a particular state of mind. So it was a fundamental misdirection. But Lord Steyne is saying here, well, the evidence, essentially saying the evidence was overwhelming, and there was no way that the prosecution would not be able to make good the burden and standard of proof. And Lord Clyde had said the same thing, and that's cited at paragraph 14 of the judgment. Dowsett. And then can I, because it may be convenient to deal with paragraph 15 of Dowsett, just to identify the different categories of Article 6 violation. And Dundon is cited in paragraph 15. Dundon is in the bundle, but it's perhaps convenient just to look at it in the citation in paragraph 15. And reference is made to a number of cases. And there was the case of Toa, which was an impartiality case. And there's a subsequent case of Hanif and Khan, which I've added to the bundle. Lord Thomas says if it's a question of if the defendant hasn't had an impartial tribunal judge his case, if that's the violation, the conviction must be quashed. There's reference to Lambert, which was a directions case. So the question, it depends. Depends on other factors, whether the conviction is safe. There's a reference to Mills and the case of Webber and others. They were delay cases, and it's never been the case that an Article 6 violation on the basis that the trial wasn't within a reasonable time leads to the quashing of the conviction. But that's dealt with by reference to reductions in sentence, as actually happened in the case of Mills. So it's not the case that an Article 6 violation automatically leads to a finding in relation to safety. And in the present context, can I see how that was addressed in the case of Cadder, which is at Divider 7, so the seventh case in the Leonard Friends bundle. A Scottish case where there was a procedure in Scotland that permitted the police to question a suspect in certain circumstances before they'd been given their legal rights. And that was found to be a violation of the Convention. And the relevant passage is at paragraph 64, which is Lord Hope's judgment. Having found that there was a violation of 6.3c and that the evidence that this procedure had yielded reliance on it amounted to a violation of 6.3c. What Lord Hope said, the result of this was, in terms of safety, was as follows. Counsel invited the court simply to allow the appeal and quash the conviction. But that would only be appropriate if it was clear that there was insufficient evidence for a conviction without the evidence of the police interview, or that, taking all the circumstances of the trial into account, there was a real possibility the jury would have arrived at a different verdict had they not had the evidence before them. And the case of McKines is cited. That is the standard approach. It goes back to the Crown and Sterling, this court's decision from 1944, the approach to the question of safety. When evidence is put before the court that ought not to have been, is the only reasonable verdict one of guilty.
Are you going to address at some point on the preceding passages in CADA which deal with the approach following Zaldus and Turkin, whether there's a clear and consistent
And whether
constant jurisprudence in relation to the principles of that case laid down?
well, what I would say about that is this. The clear jurisprudence of the Strasbourg Court is that, first of all, where someone has been denied access to a lawyer, the determination must be made as to whether there were compelling reasons for that denial. And secondly, the court will then go on to determine, in either case, the question of overall fairness. And that is what the Strasbourg Court did, the Grand Chamber did in the appellant's case. That was the approach. And that approach was based on a clear and consistent line of authority. And
So you said, you just dropped your voice, I didn't hear you. You said that was what the Grand Court did in
the appellant's case. That was the approach that they took in analysing the Article 6 question. That two-stage approach was based on a clear and consistent line of authority. The conclusions they reached in the appellant's case are simply their conclusions on his particular case.
that they introduced they applied a refinement to that, didn't they, in identifying the particular burden of proof that lay on the state. Now, do you say that that element of the test they applied was part of a consistent jurisprudence?
I'm not going to contend that was, but in Zaldus and Turkey, the court had certainly taken the two-stage approach.
Yes, that wasn't my question really. I concede that the taking of a two-stage approach was a part of a consistent jurisprudence, but was the application of a high burden of proof on the state to justify stage 2 if stage 1 is met, was that a part of a consistent?
That wasn't. That wasn't.
That was totally new in this case, wasn't it?
And it was significant because the conclusion at 311 relies on not simply a burden on the state, but a presumption
Yes.
of unfairness and a high threshold.
Yes.
And it was expressly against those matters that they reached their ultimate conclusion.
Yes. So I'm just trying to understand then what your position is. Was the decision of the Grand Chamber in this case the application of a consistent line of jurisprudence in Strasbourg, or was it a development of a consistent line of Strasbourg jurisprudence?
It was a development in that regard. in terms of the two questions, that arose from Saudats and Turkey.
Are you trying to draw a distinction between the status that that we should be according to a statement of principle found in the Strasbourg authorities on the one hand, and on the other hand, a decision applying that principle to the facts of an individual case? It sounded a moment ago like you were trying to draw a distinction between those two things in terms of the status that we should give to what Strasbourg has said.
Well, there is a distinction between them to this extent, that the application of facts in a particular case is plainly a single issue judgment. It is not the basis of a clear and consistent line of authority.
Well, we can see that to this extent that there wasn't much disagreement between the majority and the minority opinion on the relevant legal principles, but it was how they played out on the facts.
Yes. Yes, and the minority found on the facts the disagreement was from the start. It was started on compelling reasons. So
you were looking at CADA.
Yes.
And what Lord Hope said in paragraph 64.
It was simply, my lady, to point out or to make good the proposition that where the violation concerns evidence and it is concluded on the basis of the violation that evidence ought not to be admitted, but the finding of a violation, the finding that a conviction is unsafe is not automatic, but depends on an evaluation of the other evidence in the case to determine whether or not the conviction is unsafe. And then what I'll seek to do in a moment is make some observations, some submissions in relation to that question in the context of the appellant's case. Can I, before I do, touch on a matter that was raised in relation to the Grand Chamber's, the majority's judgment as to what happened at the trial and its significance. Because what the Grand Chamber was doing after finding that there were no compelling reasons was analysing the question of overall fairness. But in the submission of the Crown, that was an exercise that had in fact been carried out at trial and on appeal. Because one of the key procedural safeguards where a code has been breached is the ability of a defendant to seek the exclusion of the evidence under Section 76 and or Section 78 of PACE. In this case, that application took the form of a hearing at a voir dire where evidence was called And there was judicial determination in relation to two aspects of the witness statement. First, the reliability of the statement, including circumstances surrounding the making of the statement that might make it unreliable. Whether or not it in fact made it unreliable. So there was a broad examination of the reliability at the domestic level. Secondly, the judicial determination considered the question of overall fairness in relation to the admission of the statement. And one of the matters that the court is obliged to consider under Section 78, its general discretion, is the circumstances in which evidence was obtained. And in relation to that analysis at the domestic level, all of the matters identified by Strasbourg in relation to the defects in procedure were identified and recognised and assessed. In fact, they were conceded by the prosecution at trial. And so, in a domestic context, the analysis conducted by Strasbourg, or the factors identified by Strasbourg, have already been considered in order to determine whether or not it would be fair and lawful to admit the witness statement. And not only was that considered by the trial judge, but of course it was also considered by this court in the first appeal. And the submission of the Crown is that the availability of Section 76, reliability, and Section 78, overall fairness, as procedural safeguards, are very important and are apt, by their very application, to serve to guarantee and protect the fairness of criminal proceedings.
Yes, I mean, that was the approach that's certainly adopted in relation to the first three applicants.
Yes. It was, but the fact remains that all of these points that Strasbourg identified were considered by the trial judge and the Court of Appeal in the context of fairness. And the simple point the Crown make is that is a very important procedural safeguard to a defendant in criminal proceedings.
Plainly that's right. Where does it take us? Where does it leave us now, hearing this on reference?
Well, the Crown obviously accepts that the Grand Chamber has made its finding. And the Grand Chamber has found that those procedural safeguards, together with others, did not save the case from the finding of a violation. And the Crown note that. But nevertheless, as the minority found, they were very important safeguards. And
so your submission is that we too note that was the finding of the Grand Chamber, but you say on the question of safety, we can have regard to the fact that the trial judge and this court concluded that those matters notwithstanding, conviction was safe.
Yes.
That's what the Court of Appeal found.
Yes. Yes. And the fact that it wasn't just the Section 76 and 78 safeguards, the matter was also litigated before the jury.
Yes, yes.
The different question. And there was the statement was subject to an express judicial direction, which, once the statement is admitted, it requires a direction, but it can't be regarded as an excessive discretion to permit the jury to have regard to the statement, consistent with the terms of the direction. It simply cannot be the case. It's not how the jury system operates. And the jury had in fact been directed, and this is at page 67 of the summing up. That's the CCRC number. It's at page 15 of the internal page 15 of the judgment. The last substantive paragraph. The question isn't whether you, the jury, think it's fair that he's being tried. If you think the statement was or might have been obtained by something said or done which was likely to render it unreliable, you must disregard it, even if you think that it was or may have been true. That's the Section 76 direction. Even if the jury thought it was true, they were being directed to disregard it if they took a particular view of the circumstances in which it was made. And in the submission of the Crown, that cannot be regarded as giving the jury an excessive discretion. And it may be that on the analysis of the Grand Chamber, once they had found that there was the procedural irregularity, it's difficult to know what kind of discretion would not have been excessive, having regard to the finding of the Grand Chamber. My Lord, my Lady, can I move to the other evidence in the case?
Yes.
So it's just before you do, forgive me for interrupting you again. So you're saying that given the Grand Chamber's findings, it's difficult to see how any discretion could have been left to the jury in relation to the statement?
Yes. It's difficult to know what it was they meant by excessive discretion or latitude, how the Grand Chamber thought the judge should have confined the analysis of consideration of the statement. And it appears to be, because a proper delineation between the role of the judge and the jury hasn't been appreciated, or at least hasn't been outlined in the judgment. In the end, it was a matter for the jury to consider the statement in accordance with the appropriate judicial direction which had been given.
One thing that might be said in relation to that comment about discretion or latitude is that it shows that the Grand Chamber did not equate the question of whether the admission of the statement gave rise to unfairness with the question whether it should not have been admitted. Because the Grand Chamber was contemplating that some lesser degree of latitude might have been consistent with Article 6. And that can only have been a lesser degree of latitude in circumstances where the statement was still admitted.
Exactly. And that's why we say that the finding of the Grand Chamber does not even amount to a finding that the statement ought not to have been admitted. It's not analysed.
It's not entirely clear whether that is the case or whether this was the procedural irregularity as it was effectively operated as a block on any part of the trial being fair. It's not entirely clear from what they say whether it is, as my lord says, that is what we should draw from it, or
Yes.
something more fundamental. They obviously had to deal with the question of what direction had been given to the jury because it was part of the government's case that this led to a trial that, looked at as a whole,
Yes.
didn't breach the appellant's rights under Article 6.
That serves, in my submission, to underline the difference between the analysis that the Grand Chamber were conducting in relation to Article 6 on the one hand, and the question of safety on the other. And what they were not equating, even finding that there was a violation and that the proceedings were unfair, they were not equating that with whether or not the defendant should have been convicted. And it's clear why that should be the case, because Article 6 contains a whole number of guarantees, many of which are procedural. A classic example is the right to have a fair trial in a reasonable time. That can never say anything about the safety of a conviction on the evidence. But it is a procedural safeguard that Article 6...
Well, not at the moment. Can't make predictions.
No, but it never has, and that's not how the domestic courts have approached it. But even if at its height, the decision of the Grand Chamber would lead a domestic court on review to conclude that the statement ought not to be admitted, the evidence was overwhelming, and the only reasonable and proper verdict in the case was one of guilty. And may I, really in bullet point form, say something about that other evidence?
Yes.
There was closed-circuit television showing the meeting of the appellant and Osman on the 23rd of July and their progress from a train station to the appellant's flat. And coupled with that, there was footage of the two of them leaving together on the 26th of July, 3 days later, when Osman was on his way to Waterloo. So the incontrovertible evidence was that the appellant had sheltered Osman. That was also evidenced by cell site data, which was consistent with Osman having used his telephone inside the flat. And that gave with it the inference that over the course of that time, the appellant had provided him with shelter, with food, and, as could be seen on the closed-circuit television, a change of clothing. The CCTV evidence also showed the appellant meeting a co-defendant, Wabi Mohammed, and taking from him a camera and bringing it back to the flat. That was the camera on which the suicide recordings had been made. Again, that was incontrovertible evidence. In relation to the passport, there were two particular pieces of prosecution evidence. Of course, it could be proved that Osman had left the country on his brother's passport. The question was, how did he get his brother's passport? The first piece of evidence was that call data showed the appellant calling Sharif, the brother, and the clear inference was that that was to arrange the passport. And secondly, there was cell site telephone evidence which was consistent with the appellant and Sharif meeting on the 25th of July, even though they were not well acquainted with one another. And the overwhelming inference, simply from that evidence, is that the appellant, at Osman's direction, contacted Osman's brother to arrange a meeting to pick up the passport so that Osman could leave the country. That contact and that movement was never explained by the appellant, not in his witness statement or his police interview under caution, and not during the trial, because he declined to give evidence, which itself gives rise to an inference. And then there was the three other short pieces of evidence that the newspaper relating to the bombings with the appellant's fingerprints on it, with pictures of Osman in it. Telephone contact with Osman after Osman had boarded the Eurostar, including attempted contact from Osman once he had got to Italy. And finally, admissions made by the appellant in his police interview under caution, which amounted to him saying that Osman had indeed stayed in the flat, Osman had claimed to be the bomber, but that he, the appellant, didn't believe him. And the overall submission in relation to those points is that that was exceptionally strong evidence, both in relation to the provision of assistance as a matter of fact, and also his state of mind, his knowledge or belief in relation to what Osman had done, and also why he was acting, with what intent he was doing these things for Osman. His case was, these were all innocent errands, and the Crown say that that's simply implausible on the facts. And finally, in relation to the evidence, that there was the evidence of Sharif himself and Osman, to the effect that Osman did indeed ask the appellant to pick up the passport, and from Sharif that he did so. And it's right to say, of course, that that's evidence that can be treated with a degree of caution, but it was entirely consistent with the prosecution evidence and was devastating. So those are the matters that the Crown would draw to the court's attention in support of the submission that even without the statement, the only reasonable and proper verdict was a verdict of guilty. The conviction isn't unsafe. My lady, subject to any further assistance, those would be my submissions.
To make a reply, but what sort of length do you think it will be?
A short response.
Short response.
How short is short?
Yes.
Maybe perhaps after lunch would be a good time. Thank you, my lady.
We'll rise. We'll sit again at 2 o'clock. Thank you.
All rise.